All right. So we are also recording this, and we would like to afterwards, segment the stuff and segment the recording and probably, try and fit it into some sort of podcast format that we can ourselves put up on our socials and on the IPPR website. So this is just to as a disclaimer that this recording will also be used by ourselves, the IPPR, and by Global Partners Digital for reporting purposes. So that said, thank you very much, everybody, for making the time to be here with us this morning and part of this very auspicious discussion on this very auspicious day. Of course, today is International Day for Universal Access to Information, and we wanted this. I specifically wanted this meeting to fall on this day. There are some other events, of course, happening today that kick off today. For instance, the Forum for Internet Freedom is kicking off as well online, and a lot of the discussions will also be looking at some of the issues that we will be talking about in this meeting this morning. So I mean, you can the Forum for Internet Freedom, FIFA Africa, is a 3-day event, and I mean the discussions are continental, and you can I would encourage you to try and get into some of these discussions and be part of what is happening on the continent in this space. So I mean, very much the issue for us is very much transparency, accountability, and democracy, and that is that is why we have decided to have this discussion and to look at the dangers to democracy that emerging legislation around in the digital space that will impact digital rights and human rights online and offline, and it is becoming concerning. But it's not just happening in Namibia. I mean, the concerns are not just here. The concerns are regional, and they're continental, and they're global. And I think this is an opportune moment, an opportune day to have this talk, to discuss the dangers, to have a dialogue around these issues, and to make people aware of what's happening and what could happen. And specifically Namibian civil society, which we want to invite to become part of the discussions, be more involved in the processes, the law and policy-making processes around the digital and online space, and to take an interest what's happening in these spaces in terms of human rights, as we feel some of the issues here in this space, some of the emerging issues are highly concerning and should be monitored by Namibian civil society, and that's the basis for why we decided to have this dialogue and to call it dialogue on dangers. And for that purpose, we have asked some of our associates in the SADC region, from Zimbabwe, from Zambia, and from Lesotho, to be part of the discussion, to give the regional perspectives, to give to provide their experiences on what happened in their context when they had to engage with state authorities around cybercrime, cybersecurity, and digital rights, and what can we learn from what happened to others in our neighboring countries that had decided to do advocacy work in this space, in the digital rights space, in the cybercrime law and policy making space. So that is why we've decided to have this talk. That's the background, that's the context, and that, in short, is my introductory comments on why we're meeting here today. So what we'll do immediately is, I think all of you can see the program that is up on the screen. that Daniela is sharing. So what we'll have is we have the morning's program in two parts. The first part ends at 11 o'clock, so about 2 hours from now, and then we'll have a short refreshment break to just, I mean, it becomes tiring and to just be sitting in front of your computer and you know, after a while you sort of zone out and switch off. So we'll take a short break at 11 to 11:15, and then we'll come back for the second session, and which will run until 1 o'clock. So that's just sort of a time period to guide us. If we finish before then and the program has run its course before then, before 1 o'clock, then that's good. But we've sort of scheduled this to go until 1 o'clock today. So as you can see, we have 3 case studies. So I will be doing the case study on Namibia, just sort of an introductory presentation on where we are at this point in time and why we would like people, not just civil society, but Namibians in general, to take an interest in what's happening in the cybercrime law and policy making space. And then we'll have case studies from Zimbabwe, Zambia, and then have the refreshment break, and then afterwards the case study from Lesotho, and then we'll have Daniela Schniedring from Global Partners Digital talk about a tool that Global Partners Digital developed to assess, you know, whether cybercrime laws meet best practice. And then we'll end off with an open discussion. And you know, if you have any questions, if you have any suggestions, that will be where you can engage with us. But we also have Q&A sessions sort of halfway through both segments of this program. So if you have any questions, let us know. So with that said, I'm going to go into my presentation. I think, yes, I think this is better if Daniela handles the. So this presentation is Namibia is, I'm basically asking the question, cybercrime lawmaking a threat to human rights? Is what's happening in this space at this point in time, is it a threat to human rights? Daniela, can we move on to the second slide? All right. So, so this is what's busy happening on the continent. This is what's busy happening internationally. There's been a surge in legislation and policies to combat cybercrime, and you know, a lot of these laws have been used to punish, to surveil, to repress protesters, opposition actors, journalists, civil society in various countries. And this is not to say that cybercrime, terrorism, online terrorism, inciting violence and manipulating elections, for instance, is not a genuine and serious global concern. But these sorts of threats are being used as a pretext for you know, to repress. And that is exactly what the UN Special Rapporteur on the Rights of Freedom of Peaceful Assembly and of Association said in a report on 17 May 2019, a report that was published on 17 May 2019. So this is the context. This is what's happening in this space internationally and globally. Can we move on to the next slide? So, I mean, in terms of what we've been experiencing as civil society in our engagements in this space, in the cybercrime law and policy making space. There was the, I don't know if many of you, especially our Namibian participants here, can recall the Electronic Transactions and Cybercrime Bill of 2017. So in February 2017, out of nowhere, without warning, the former Minister of Information and Communication Technology, Shakero Tweya, tabled in February that year the Electronic Transactions and Cybercrime Bill. And then, I mean, it had hardly been tabled, and then it was pulled out of, it was pulled out of Parliament, out of the National Assembly. And no reason was given why it was tabled so suddenly and why it was pulled again so suddenly. And I mean, it became very evident to us in civil society, especially in the Action Coalition, the Access to Information Coalition, that there were serious issues with the draft text that had been tabled in Parliament, in the National Assembly. And it didn't look like a document, a substantive draft that should have actually made it as far as a tabling at that point. And what followed after the withdrawal of this bill, of this document from Parliament, was that, and you see there, I have it in sort of single inverts, a period of consultations followed. But these weren't real consultations. They were more or less, sessions where civil society, the public, the tech sector here, were just sort of informed about what was in this text, and so forth. And it wasn't clear that the text would be changed at that point. And from our side, as civil society, as the Action Coalition, we then had various interactions with government, with the relevant ministry, with the Ministry of Justice, with the Law Reform and Development Commission. We had closed door meetings, and we brought in people from Article 19, Henry Minor, who was then the director of Article 19 in East Africa, in Kenya. He came in for us and did a session with lawmakers, with internet service providers, with the telecoms companies, with the law drafters and the Ministry of ICT officials, and officials from the Office of the Prime Minister. And we had these meetings and pointed out the areas where the draft text of this bill was problematic, and how this bill did not meet the standards set, for instance, by the Malabo Convention, the African Union Convention on Cybersecurity and Data Protection, and also how it didn't meet the standards set by the Budapest Convention. So, as I said, I mean, the consultations, single inverts, appeared to be merely procedural in nature, and was clearly implied that there would be no substantial changes made to the bill that was at that point dated April 2017, and that we could and shouldn't expect any changes to be made to this bill. I think we can move on to the next slide. However, I mean, at the end of that year, into 2018, it became clear, by early 2018, it became clear that this bill wasn't going anywhere. And we published as the IPPR, on behalf of the Action Coalition, published a briefing paper on this whole process and the issues around this bill. And you can find the briefing paper. It's on the IPPR's website under publications. If you Google cybercrime, it will come up. I mean, if you put in the search box, search window there on the publications page, it will come up, and it will give a whole rundown of what happened around this specific bill. So all of this information that I'm showing you here comes from that briefing paper. which I authored at the time. And then what followed that in 2018 was, it was indicated that, which was one of the recommendations we'd made in the briefing paper of February 2018, that the bill be split into an Electronic Transactions Act and a standalone cybercrime bill be developed, as well as a data protection bill be drafted. And that was eventually what happened towards the end of 2018 into 2019. And in 2019, we had the Electronic Transactions Act passed. But here, some history on that that Electronic Transactions and Cybercrime Bill. It emerged from ITU processes from 2008, which ultimately produced the Computer Crime and Cybercrime SADC model law, which, I mean, some of my colleagues in the region can tell you has become a problematic initiative by the ITU and SADC, and some of the cybercrime laws and policies in the region were based on this problematic document. So the 2013 draft of Namibia's Electronic Transactions and Cybercrime Bill was a direct result of the ITU-led process. And the bill that was then dated April 2017 was almost an exact mirror image of the bill that was dated 2013. So the ITU guidelines contributed to highly flawed and human rights violating laws being promulgated across the region and across the continent. And in 2016, international digital rights organization Access Now warned that the ITU guidelines were carried out prior to 2014 without public consultation. For this reason, governments should not pass the suggested ITU regulations into law, but should follow the AU convention instead. And this is the Malabo Convention that I'm referring to here. But this was what Access Now said at the time. Other international digital and human rights organizations also issued similar statements on these the laws that emerged following the ITU this ITU process, the harmonization of the telecommunication and ICT policies in Africa, the HIPSA project, and the problematic laws that emerged and policies and regulations that emerged following this ITU collaboration with African states. So there's a lot there, and you can find all this in the briefing paper that we published and that's available on the IPPR website. I think we can move on to the next slide. So the concerning aspects that we flagged around the 2017 Electronic Transactions and Cybercrime Bill was inappropriate two-in-one lawmaking. Now, this bill, the Electronic Transactions and Cybercrime Bill, combined two separate bills and completely ignored data protection, which was what what had to basically emerge from the ITU processes. So initially there was a 2013 Electronic Transaction Cybercrime Bill, and that started off as separate bills: an Electronic Transaction Bill, a Cybercrime Bill, and a Data Protection Bill. And at some point, somewhere, these drafts had been combined, and the Data Protection Bill had sort of fallen off the table somewhere, so that what we came to be confronted with was this Electronic Transactions and Cybercrime Bill, which then in 2018-19 was again split, and the Electronic Transactions Bill was passed, became law in late 2019. And the Cybercrime Bill since then has been sort of in the drafting stage since then, as well as the draft Data Protection Bill. So that was the first thing that we thought was inappropriate, this two-in-one lawmaking. So the bill also had issues with the definitions, even for cybercrime. So I mean, it was severely lacking on the score on very key definitions that spoke to serious criminal activity and to serious other issues in the bill. There was a confusing arrangement of cybersecurity related provisions. The draft had its clauses and provisions on certain things all over the place. It wasn't a very coherent document, legally speaking. So I mean, it was very problematic. It enabled, number 4, it enabled unauthorized access, secret warrants, and warrantless search and seizure. This was very problematic, especially this particular aspect. There was a lack of data and privacy protections. At that point, we didn't know what had become of the draft, the 2013 draft data protection bill, and this bill certainly did not incorporate any substantial data and privacy protections and safeguards. It undermined. It had provisions in there that clearly undermined encryption and anonymity, which was another problematic area, and which continues to be a problematic area in cybercrime law and policy making to this day. But this bill basically sort of enabled the creation of backdoors in technology, in software, and so on, which would have undermined strong security of devices and of computer programs. The bill generally read, that there was a general lack of transparency and access to information. And it's not to say that we felt that there needed to be access to information included in the important aspects of this bill, but the general sense of non-transparency that shone through the draft text was just very evident. I think we can move on to the next slide. 8, there was excessive and unaccountable ministerial power, which is something that isn't just characteristic of this particular bill or bills, but is something that we see in Namibian, laws in general. Excessive discretionary power vested in the position of a political appointee, the minister, and this once again was evident in this bill. Excessive and unaccountable ministerial power. Number 9, too lenient an approach to service provider intermediate liability. We felt the bill at the time didn't address the issue of intermediate liability appropriately or adequately, and that's why there's a question mark at the end. And we felt there needed to be more said in the law, in the eventual law, about in terms of intermediate liability. And then, of course, there were the online child protections, which we felt were also not well defined, and not well drafted. And our recommendation was also to not have these child online protections in a cybercrime bill, but to have these rather put into and strengthening the child care and protection act of a few years ago. I think it was 2015, if I'm not mistaken, 2014 or 15. So we rather felt that law needed to be strengthened with online child protections, rather than have these vague provisions in the cybercrime law that we thought at that stage would become law, this electronic transactions cybercrime bill. So in our assessment, the electronic transactions and cybercrime bill was substantially weak on adequate and appropriate judicial, legislative, and public oversight mechanisms to especially prevent abuse of potential communication surveillance and interception provisions and mechanisms. So this was what for us was very problematic about this bill. The oversight mechanisms were severely lacking. There was a lot of power vested in the minister. There was no oversight over the offices and bureaucratic institutions created in this bill, and law enforcement, and that was just problematic. And this speaks to the level of, or the inappropriate levels of transparency and accountability. I think we can move to the next slide. So I mean, while all of this was still just in 2017 when we were engaging on these issues, and we had legal experts come in. We had communications law legal expert Professor Justine Limpert-Law from Wits University also join us in sessions with government, and she also wrote an analysis of the law for the Namibia Media Trust that was then also submitted as an input to the electronic transactions and cybercrime bill. So while all of this was happening in 2017, other things were also happening. So in March that year, the Namibia Central Intelligence Service, in collaboration with other parts of government and security sector, had a workshop on preventing and countering of violent extremism with the aim of enhancing national security through collaborative efforts. At the end of the two-day workshop, the recommendations included that there is a need to urgently implement the requirement for SIM card registration, mandatory SIM card registration. And it was also recommended that there be a monitoring of social media to see whether radicalization and what sort of terrorist acts were happening on social media. But of course, this is against the backdrop that Namibia on the Global Terrorism Index is ranked as one of the countries that scores 0 on terrorist activity, on radicalization. So why we would have such stringent and such invasive security practices, and why they would be necessary was questionable. But this was the space. This was a sort of language we were starting to see around in the cybercrime, cybersecurity space, monitoring social media, looking at radicalization of the youth, SIM card registration, cell phones had to be monitored and the like. And then at the end of that year, in November 2017, the ruling party had its elective Congress, which was a very fractious affair, and which was preceded by accusations of factions spying on each other, and surveillance, state surveillance being apparatus being used to surveil certain factions in the ruling party. And at the end of this 3-day event, the ruling party Congress, which was held here in Windhoek, the party issued some draft resolutions, the Congress. And among those resolutions, it was certainly not the only one that was very concerning to us, but just to give you an indication of what the mindset was that we were sort of nervous about, concerned about at that stage around cybercrime law and policy making. One of the resolutions stated that a Ministry of Cybersecurity be established in order to control information in the social media. This is exactly how it was in the document. Control information in the social media and guard against cybercrimes such as hacking and monitor illicit flows. So, I mean, the first order of business of the cybersecurity ministry was to control information in the social media. So, I mean, this is the sort of thing that was concerning at this stage. Is if this is it wasn't to, the first order of business wasn't to go after cyber criminals who defraud people, scam people, but I mean, it sort of added on or added to comments in the public political space by politicians around respect for politicians, disrespect of seniors, senior figures, political figures, and so on. And now, monitoring social media, which sort of spoke to what the March Namibia Central Intelligence Service workshop had also issued a recommendation on. So against this backdrop, we sort of realized, this is the sort of language we're hearing, the noises being made around in the cybercrime space are very concerning, because they're not about actually fighting crime. They're actually about policing freedom of expression, policing the youth and how the youth express themselves on social media. So this was what was becoming concerning to us at that stage. You can move on now, Daniel. So, yeah, no, one back. So yeah, so around that time, so in the intervening period, the Computer Security and Cybercrime Bill was drafted, which is the bill which is the draft text that we currently have, and that has been circulating. We don't know if this is the latest version of this bill. Earlier this year, I had requested both the Ministry of ICT and the Ministry of Justice to give us an update on whether what the status was of this bill, and it wasn't very clear what was happening around this bill. The answers that we got weren't very clear on this. So I mean, the text that we have is dated 2019, and it's the Computer Security and Cybercrime Bill. So the concerning aspects of this bill, this text that we have, is once again similar to the previous electronic transactions cybercrime bill. There's a problem with the definitions. Key concepts are not well defined in this bill. There's still excessive and unaccountable ministerial power vested in a single position. We feel that access to information should not be the province of cybercrime legislation. So here, this bill, so what we have in Parliament at the moment is the Access to Information Bill. And this draft cybercrime text actually enables the Minister of ICT empowers the Minister of ICT to make sections of the Access to Information Act redundant, because he can decide discretionarily what information can be made confidential, what databases can be made confidential, and that would actually limit people's access to information. And we feel that sort of power should not be defined in the cybercrime legislation, but should be, if at all, in the access to information, eventual access to information legislation. So how how this bill, this 2019 bill, speaks to the eventual access to information law that we think will be passed before the end of this calendar year, would be interesting. So this is definitely something we're going to keep an eye on. And then, of course, there are underdeveloped provisions and clauses in there where we feel there needs to be a lot more detail and about certain aspects incorporated in the bill. Some of these aspects are really underdeveloped, and there's a lot there. Once again, we face a situation where the bill speaks to a general lack of public oversight mechanisms, where the public actually can have some sort of insights into what's happening in the cybercrime law enforcement space. These mechanisms, according to this text, if you just look at this specific text, are severely lacking. And then there's a lack of transparency, of course, that feeds into the lack of public oversight. Daniela, you can move to the next slide. So the draft bill lacks remedies in the case of illegal interception. And this is illegal interception by state and private actors. And there's a lot to be said in this space around interception of communications. But the issue is that there's a lack of remedies there. The relationship between this provision, the interception provisions of the draft bill and Part 6 of the Communications Act on interception of telecommunications needs clarification. This is of course an area that we've also been active in terms of advocacy. And we would like to see this also clarified. How would the eventual cybercrime law speak to the Communications Act and the specific sections in the Communications Act, Part 6, that deal with interception of telecommunications? And of course, that at the same time also how these two laws would speak to the data and privacy protection law. And of course, that's the last point there. The law should ensure that the right to privacy is also protected when transmitting information to a foreign authority. This is also an area that we feel is underdeveloped. There are some others, but I felt these were the salient points to just point out at this stage. Just as a something to make people aware of. In the draft National Cybersecurity Strategy and Awareness Plan 2020-2027, it is stated, and this draft National Cybersecurity Strategy and Awareness Plan there was actually a validation meeting earlier this month, earlier in September, and this draft document, which looks to be the final text, states that the current cybercrime bill is not aligned to the Budapest Convention, which is internationally recognized as the leading treaty on cybercrime legislation. The government of Namibia has indicated their desire to accede to the convention. So it's clear that this bill, this 2019 draft that we have, and I suspect it's still the most up-to-date draft, isn't up to sort of the standards set by the Budapest Convention. And it goes on to state that the government of Namibia will conduct a detailed analysis of the cybercrime bill using the Budapest Convention as the target legislation and identify areas that require modification, which is a good thing. That means that this probably isn't the final text, which means as civil society, as Namibians, concerned Namibians, we can probably still influence this text going forward, because this was what came out of a validation meeting earlier this month. I think it was the 9th of September. I'm speaking under correction. So that means there's still an opportunity for us to make a difference. Now, I just want to, in the final slide, I just want to underscore something that also appears in the draft National Cybersecurity and Awareness Plan. And it states that Namibia's the guiding principles of Namibia's cybersecurity approach. There are three guiding principles: good governance, fundamental human rights, and inclusivity, which are the things that we as the Action Coalition, that we as the Institute for Public Policy Research, and that we as a civil society, I think, are in general fundamental guiding principles that we support. So under the fundamental human rights, because this is the area that is of most concern to us in this space, it states that the National Cybersecurity Strategy and Awareness Plan should respect universally agreed fundamental rights, including but not limited to the United Nations Universal Declaration of Human Rights and International Covenant on Civil Rights, as well as relevant multilateral or regional legal frameworks.
Yeah. So you can do what you can do is you can then just make sure.
Excuse me. I think attention should be paid to freedom of expression, privacy of communications, and personal data protection. And to end off, I mean, this is where we are. This is what we support, and we would like to see cybercrime, cybersecurity, law and policy making processes reflect these fundamental human rights. Thank you very much. I'll end there. So, yeah. So what we have, I mean, that's sort of the situation we now have here in Namibia. That's where we are in terms of cybercrime law and policy making here. So if you remember, this is where we do a quick question and answer session before we move on to the regional case studies. So if there's anything that anyone would like to ask or comment on at the stage with what has been stated, what I've stated in the presentation or during the presentation, please, we can do that now if there are any questions. Can you come up here and ask here?
I wanted to ask where the website is of the briefing paper.
Oh, the IPPR website. Yes, it's on.
It's on the IPPR website. Yes. Oh, I didn't hear that.
It's under, if you go on the IPPR website and you go under publications, then we have this window where you can do a search by author, by title, by keyword or phrase or so. So if you just type in cybercrime there or you type in my name, the paper will come up. It's from either January or February 2018. Yes. For those of you online, Ms. Alwendo put the link in the chat section here on the side. Are there any questions? Any comments? All right, so if there's nothing, I think we'll move on to the case studies, and the first one we have is a case study from our associate in Zimbabwe, Nompilo Simanje. She is with MISA Zimbabwe, and please, Nompilo, when you start your presentation, just briefly introduce yourself and your what you do at MISA Zimbabwe. So I'm handing over to Nompilo now. Nampila?
I think maybe her screen froze.
Ah, okay.
She's had to drop off. I think she might be trying to join the session again. Maybe if we can wait a minute or two.
All right, I think she's back in now.
Yeah. Hi, Nampila, you're back.
Yes, I am. My apologies for the glitch.
No
It seems
worries.
my Zoom was updating. So when I tried to access the camera, it then started requesting for access all over again.
Oh, no.
Yes, but thank you very much, everyone, also for your patience. And thank you to Global Partners Digital and IPPR for convening this very important conversation. Also because we have seen so many developments in the Southern African region around cybercrime laws. And we also think it's very important to have such conversations, particularly on how these laws will impact on digital rights and more broadly on human rights. And as Frederico had mentioned earlier, my name is Nompilo Smanje. I'm a legal and ICT policy officer with the Media Institute of Southern Africa, the Zimbabwean chapter. And our work is based on several strategic pillars, which include media monitoring, media defense, but also internet governance, which is the component under which our advocacy around cybercrime laws and data protection laws has been. Under this banner as well, we have work around digital rights literacy, and we've had the campaign for over 3 years that have been implementing in 5 countries, 5 chapters: Tanzania, Lesotho, Zambia, Malawi, and Zimbabwe. And yeah, we really appreciate having this opportunity to share with you the case study from the Zimbabwean perspective. I would like to quickly share my screen so that we can get right into it in terms of what's been happening in Zimbabwe around our proposed cybersecurity or cybercrime law. But firstly, I'll start off with a history of where we started off from and where we're at now. So it's been quite a very long journey here in Zimbabwe around the drafting of a cyber law. And it all started in 2013 when a draft computer crime and cybercrime bill was developed. So afterwards, this was like a zero draft. It never made it to Parliament. And so for a gap of 3 years until 2016, there had been no movement around that proposed bill. And then in 2016, the draft bill was revised, and then a national cybersecurity policy was also adopted. But I think the key issue also that we had a challenge with, or that we were quite concerned about, was the fact that this cybersecurity policy was proposing that the cybercrime law or the cyber bill should be administered by the Minister of National Security in the President's office. So it's something I'm going to talk about later on, but already we could see that there's quite a misconception around the importance of the purpose of the cybercrime law, because already through this policy, we could see that the government was restricting cyber laws only to issues of national security, or rather their perspective of cybersecurity and the importance of cybersecurity law was mainly focused on the national security component. And then of course, the policy also provided for the drafting of the Cybersecurity Act. And then later on in 2017, the bill was then renamed Cybercrime and Cybersecurity Bill. And we had then what was proposed to be a cybersecurity threat detection and mitigation ministry. This was during the time of the then president, Robert Gabriel Mugabe. So he set up this ministry in 2017, the cybersecurity threat detection and mitigation ministry. And from what the then presidential spokesperson was saying, this ministry was a protective portfolio aimed at protecting the nation from cyber threats posed by the abuse of social media. And it was also viewed to be a necessary tool for trapping mischievous persons on cyberspace that are bent on using social media to cause instability. So clearly from this description of what the ministry was intended for, you could clearly see that the government viewed or still views social media as a very dangerous tool that causes instability in the country. It views the use of social media by different individuals for different reasons as cyber threats, as abuse of social media. So even up to now, we have seen several statements by the government through the ministries and through several other policymakers where they say the cyber bill is going to punish social media abusers. But when you look at what exactly they mean by a social media abuser, you can see also that the perspective really, or the purpose really, is to stifle online free expression. So people that use social media to criticize the government are viewed as abusing social media. People that use social media to call for transparency and accountability by the government are also viewed as abusers of social media. So this was where we were at in 2017. And then in 2018, we then had, that's when we had a new regime. And the then Minister of ICTs and Cybersecurity then pronounced that there was going to be development of principles for an omnibus law, which law was going to be a cybercrimes, data protection, and electronic commerce bill. And I think this also relates to what Federico was saying earlier, that we have seen in the region countries bunching up substantive issues, because when we look at the cyberspace, there are so many issues that are involved, and cybercrime is just one of them. But also data protection is another aspect. And then electronic transactions or e-commerce is another aspect. Excuse me, can you all hear me?
Yes, we can hear you, Nampila.
Okay, great. I had some background noise. No, that's all right. So just to link that to what Federico was saying, we can clearly see that when we speak about laws or policies that relate to the cyberspace, there are so many components to it. And it's actually a dangerous precedent to introduce omnibus laws or to bunch up several issues into one law, because we saw that also even here in Zimbabwe. I'll get to that. But when this was announced in 2018, as Mr. Zimbabwe, we strongly spoke against it. And we even did commentaries that looked at other jurisdictions like Kenya, like South Africa, to clearly show how it's a bad idea to have an omnibus law or to have a model law on the cyberspace that touches on all of these substantive issues, with one of the key issues obviously being that the issues are not then properly provided for. There will be so many vague provisions, but also so many gaps in the laws, because the law will be bunching up so many aspects of regulation of the cyberspace. And then, of course, in 2018, also our national policy for ICTs was adopted. And basically, it's a 5-year policy which seeks to develop and promote appropriate security and legal systems for e-commerce, including issues relating to cybersecurity, data protection, and e-transactions. And then in the period 2020 to 2021, that's when we officially had a draft cyber law that was gazetted, because all this time there were these conversations and these draft laws were put into place and they were revised and the likes, but they never made it to Parliament. But in May 2020, the Cybersecurity and Data Protection Bill was gazetted. And also there was a call for submissions by stakeholders, which we did. We made submissions to the Clerk of Parliament. And then in July 2020, there were public hearings. In terms of our lawmaking process here in Zimbabwe, when a law is gazetted, the responsible parliamentary portfolio committee has to take that bill to the public. So there's always a parliamentary portfolio committee for every ministry. So this bill was produced from the office of the Ministry of ICTs. So the parliamentary portfolio committee for the Ministry of ICTs then worked together with the parliamentary portfolio committee for the Ministry of Information, Publicity and Broadcasting Services to then conduct public hearings. Unfortunately, we are also at the peak of the COVID-19 pandemic here in Zimbabwe, and there are so many restrictions in terms of travel and also in terms of public gatherings. So as a result, not many people could be mobilized to participate in these public hearings, but nevertheless, the public hearings proceeded. And then there have been so many other developments since then until July 2021, which include that when the public hearings were concluded, the Parliamentary Portfolio Committee produced a report which had recommendations on how the bill needed to be amended. And we actually recorded that to be impact from our end, because the recommendations from the Parliamentary Portfolio Committee in their report had so many of the suggestions that we had also proposed. So in July 2021, the law then, between then and July 2021, the law underwent first and second reading. These are the readings in Parliament between the upper house and the lower house. So it's the National Assembly and the Senate, but also the Parliamentary Legal Committee that will be involved also in the process. And we understand that when this bill went to the Parliamentary Legal Committee, they issued a report saying that this bill was a non-adverse report, meaning that the bill is aligned to the Constitution and that its provisions are constitutional. But then also in July 2021, when the bill was then sent to the Senate for the third hearing, the Senate recommitted the bill to National Assembly, and their position was that there were so many errors in the bill, which errors could not be amended in the Senate, but had to be taken back to the National Assembly. This was also because the law has undergone several amendments from the time that it was gazetted in May 2020 to date, with the amendments also involving submissions by stakeholders, the public hearings and the report by the committee, but also the debates in Parliament, although some of the reports have noted that there were no extensive arguments or debates around the bill from the parliamentary perspective, but also the line ministry has also been proposing amendments. And it's something also that we have had a challenge with, because we understand that the bill has changed substantively, and we have been calling for the bill to be taken back to public hearings. And then, of course, in September 2021, the position is that the bill is with the president and it is awaiting presidential assent. So there's a high chance that our cybersecurity and data protection bill will be enacted into law by end of this year. Now, I want to move to what have been our human rights concerns around the bill. I just selected a few aspects. Firstly, one aspect being that this law was proposing that our telecommunications regulator, POTRAS, be the administrative body that handles the Data Protection Authority and also the body that handles the cybersecurity authority. So this is a challenge because firstly, the law is vesting 3 roles into one body, which is POTRAS, creating a very super administrative power. But also when you look at the functions of these bodies, you see that there's a potential conflict of interest, because POTRAS as the telecommunications regulator has access to data from the telecommunications spheres. And there's a chance that in exercising its role as the cybersecurity center, it will also use some of the information or the data that it has access to as a telecommunications regulator to pursue the issues relating to cybersecurity. And that's a problem now when you're dealing with the government or with policymakers that view cybersecurity as national security, because then there's going to be possibly entrenched surveillance, but also violations of data protection and data privacy. And also, this is also a challenge because the independence of POTRAS as a body has always been questioned. particularly because there's so much involvement by the ministry, and obviously the ministry is a member of the executive. So the independence of Portrait as a body itself has been questioned, and we believe it's compromised. So that's another issue that we're looking at. But also lack of independence, because already they're providing for a data protection authority, but this authority is also going to be under the oversight of the ministry. So there's lack of independence, and actually that's also contrary to international standards and best practices. And then the other issue of housing the cybersecurity authority in the president's office, it's something also that was discussed and will possibly be in the amendments that have been done on the cyber law. And then because it's a law that is touching on data protection and cybersecurity, we noticed that the law was not providing for notice to the data subject in the event of a security breach. So for instance, should there be a security breach at any of the public hospitals, or maybe even at any of the local banks, or even at the mobile network operators, the law was providing for notification to the Data Protection Authority, but it made no mention of notice to the data subject, which is something that is quite critical, because obviously when there's a security breach, there's definitely compromise in terms of data privacy and data protection for the data subjects concerned. And then the law was also not providing for explicit provisions on rights of data subjects. There's so many rights that are involved. For instance, the right to access information, the right to be forgotten, right to deletion, that when information is collected within a specific period of time for a specific purpose, post that purpose, that information should be deleted. The right to be forgotten is linked with that. The right to correction, the right to access, just to know what information an information officer or a specific institution has on you, the right to access that information. All these rights were not explicitly provided for in the law. Now, when we move to I've skipped the slide on other important issues. So also there were issues of criminal sanctions on civil offenses. For instance, in Zimbabwe, criminal defamation was outlawed, but we noted that some of the provisions in the law are now bringing in criminal sanctions, which might end up then smuggling back criminal defamation. Defamation based on communication published through electronic devices or electronic or social media platforms. And then we noticed that also there were several provisions in the law where there were exceptions based on national security and public interest. I'm sure many of you will agree with me that national security has always been a very mysterious concept. What exactly falls under national security? What exactly falls under public interest? In most instances, it has not been properly defined. So we noted that also even in our cybersecurity and data protection bill, that the law was providing exceptions to cross-border transfers of data, exceptions to processing of biometrics data, processing of sensitive information on the basis of national security, without necessarily explicitly providing what exactly or what aspects of national security will be considered under that aspect. And then, of course, it also had a provision on whistleblower protection, because you have seen developments where whistleblowers are relying on electronic devices and social media platforms to communicate. For instance, those who have been following developments in Zimbabwe, there was our Ministry of Health, our former Minister of Health was exposed. He was found to have been involved in corrupt activities relating to awarding of tenders and also relating to COVID-19 funds. So how this information came about, it has been communicated that someone communicated to local journalist Wopo Chingono with information on what was happening in the ministry, and also with some documents on who had been awarded the tender. And then following some extensive investigative journalism, it was then, the ministry was then exposed, or the minister himself rather, was then exposed, resulting in him having to leave office. So when this law provided for whistleblower protection, which we believe is very important, not only for journalists to be able to undertake their role as the fourth estate and the watchdog, even for purposes of access to information and broadly for purposes of transparency and accountability. So we noticed that the law was providing a very skeletal provision with no substantive mechanisms for the protection of whistleblowers. So that was also something that we're quite concerned about, because from the framing of the provision, we could sense that there's a higher chance that this law might be used to then punish whistleblowers, or in the worst case scenario, because it's not substantive enough, it will then lead to data privacy and data protection compromise for whistleblowers. And then wide and vague provisions. This pattern we have seen in Zimbabwe for quite a while, but an example that I want to give is on incitement of violence. So we have a provision also in the bill which criminalized incitement of violence. But I want to give you examples of what incitement of violence has been in our country for you to understand how this law has then been, or how this provision has infringed on freedom of expression and broadly on human rights. So for instance, in 2016, we had one pastor, Ivan Mawarire, who started doing videos, and he was talking about the increase in prices of basic commodities in Zimbabwe. He was talking about increase in fuel prices, basically the increase in basic commodities, which are quite critical for ordinary Zimbabweans. So when he started doing these videos, now there were issues around protests, and then people were mobilized online, and there were protests in Zimbabwe. I remember it was #ThisFlagZimbabwe. Then there were several other peaceful demonstrations also, and stayaways where people were just staying from home, like a national lockdown, a national shutdown, where people were protesting peacefully against the issues around basic commodities, access to basic commodities. And he was charged with incitement of violence. He was charged also at one point with an attempt to overthrow a legitimate government. So we have seen these provisions being implemented. Hope Ochingwono also is another journalist who was arrested on this same provision when he was also talking about issues of exposing corruption and getting the government to be transparent and to be accountable. And then he was charged also with inciting violence. We had also the online movement that we had in Zimbabwe on Zimbabwean Lives Matter campaign, which was a campaign against human rights violations. But prior to that, the country, or basically citizens online, had mobilized themselves to do a protest, which was under the hashtag 30 July 2020 movement. And then as a result of that, Hope Ochingwono and other opposition leaders were also arrested for inciting violence. So this same provision also, which we have seen at play in our Access to Information and Protection of Privacy Act, which we have seen at play in our Criminal Law and Codification Act, was also provided for in the cyber bill. So this was quite an issue for us because we noticed that, you know, these provisions keep on being regenerated, and we have seen them at work, and there's a chance that we'll continue entrenching infringement of freedom of expression. And then also there's the issue of the criminalization of publishing false information. And our issue has been firstly that, you know, there's a difference between misinformation and disinformation, with one being a deliberate attempt or a deliberate intention to mislead, while the other is, you know, publishing information on the basis or on a genuine belief that it's true. So we saw that also this law was very vague in terms of the regulation of publishing false news, more specifically that it was not providing for these clear distinctions, because at law, what is very important also is that knowledge of falsity should be a requirement of that law, that you should have known that it was false, but also that you should have intended to mislead or to, you know, to propagate false information, or maybe to even cause instability using that false information. So that's also something that was quite an issue for us, because in Zimbabwe, we also have a constitutional court order which declared that false news offenses promote self-censorship, that false news provisions are unconstitutional. So the fact that the cyber bill was also resuscitating that same provision is something that we also have a problem with. And then the law is also providing for the use of remote forensic tools. And one example was the keystroke logger, which can be either in software or hardware, that is used to detect the information that someone types on their keyboard. be it on their laptop or on the iPad or whatever device you'll be using. But this keystroke logger allows a third party to access the information that you'll be typing on your keyboard. And our law was allowing the use of such tools, but broadly also even the use of remote forensic tools. Our problem was that the law is also providing for their use without procedures on oversight. So for instance, that there should be a procedure on who is going to be using these remote forensic tools. For instance, under our Intersectional Communications Act, the law allows the police, it allows the Tax Revenue Authority, it allows someone from the president's office, it allows someone from the army, I can't remember the fifth person, to request for a warrant for interception. So in this instance, the law was not providing on who should have access or who should use these remote forensic tools. It had no provision on under what circumstances such tools can be used, because obviously they are highly invasive tools and they should be used in exceptional circumstances. The law was not providing for when they will be used, or even procedure in terms of where do you get the warrant from, how long would the warrant be valid for, what do you need to do if you fail to use that tool within the prescribed period, can there be an extension, and under what circumstances can there be an extension? The law was very quiet on that, and that's quite also a challenge because we feel it's definitely entrenching surveillance. So I think this is going to be one of my two last slides, just to make sure I'm still within my time. I'll speak to the MISA advocacy strategy, MISA Zimbabwe advocacy strategy. So I did mention earlier that, you know, when all those developments would do commentaries and the likes. So when this specific bill was gazetted, we did commentaries and we did fact sheets upon the gazetting of the bill. And then thereafter, we relied on those commentaries and fact sheets to make submissions to the Clerk of Parliament and the Line Ministry, being the Minister of ICTs. And then we relied on the fact sheets to also do awareness campaigns through community engagement meetings. So we did countrywide engagement meetings where we would move around the country, get people together, explain why cybersecurity laws are important, explain the provisions of the law and how they are going to affect their exercise of rights. And this was very important also because the members of the public contribute to public hearings. So they needed to be capacitated to know what the law is saying, to know how the law is going to affect them, so that when the public hearings commence, they will then be able to contribute meaningfully to the conversations and also contribute meaningfully to what changes need to be made. And then because we're also monitoring the public hearings, we had a team of 3 people that moved with the 3 different groups from Parliament. So we'd move with these 3 groups, monitoring the public hearings in their countries, documenting what the members of the public were saying. And based on that monitoring, we then produced also a shadow report on the public hearings. So our shadow report also would then highlight the recommendations that members of the public were using. And then when the Parliamentary Portfolio Committee also releases its committee report, we then juxtapose also with our report, highlighting some of the differences, some of the issues that they did not capture, some of the recommendations and how they are important or how they are detrimental to the exercise of rights. And then post that, or post the public hearings, we also did capacity building of policymakers. And what I want us to appreciate is that because people are voted into Parliament on partisan lines, there's a very high chance that our policymakers are not capacitated enough to handle issues relating to cybersecurity or broadly issues relating to ICT policies and laws. So we also undertook capacity building workshops where we're engaging with the policymakers and training them on international standards and best practices on cyber laws, but also the key issues that we're noting within this law. And we also did a multi-stakeholder engagement. This involved several people, some from within the region, but also some from outside the region. And this multi-stakeholder approach was aimed at ensuring that, you know, we all speak with one voice in terms of how the law should be framed or how best we can produce a very good law. So some of the people that contributed to this were colleagues from Google, colleagues from Facebook, but also even the private players, players in the telecommunications industry, We also worked closely with UNICEF because the law was also providing for safe use of the internet or the cyberspace by children. So we had to bring in all stakeholders from the media, through the Media Alliance of Zimbabwe, for all of us to contribute to these conversations and to the best framing of the law. We also utilized our regional networks. Several regional partners wrote letters to the government, to parliament. They made submissions on making suggestions on how the law should be framed, and emphasizing also issues that the policymakers need to take into account. So that was quite useful as well. I mean, MISA Zimbabwe and broadly also the MISA chapters are part of several coalitions regionally and internationally. So we benefited quite strongly also from those regional networks. And then when the law was now out of our hands, when the law was now undergoing the parliamentary process, we would do communiques on developments around the law. And in these communiques would still emphasize on our position and emphasize also on the things that need to be changed. So for instance, when we heard that the law had been recommitted to the National Assembly, we wrote a letter to Parliament and to the ministries and the committees, and we're calling for that law to be brought back to public hearings. And the argument was that the law has undergone several changes. And there's a very high chance that when the law is enacted, we are all going to be surprised. It might even be entirely divorced from some of the issues that we discussed and some of the issues that we thought had earlier on been adopted. So we did a letter which we then distributed to the different important stakeholders, requesting for that law to be brought back to public hearings. And then when the law was not brought back to public hearings, but instead was moved to the president, we also did a petition to the president, calling on the president to decline assenting to that bill and send it back to public hearings as well. So these are some of the strategies that we have taken. Federico, I note that I am a bit out of my time. I think with 2 minutes, please allow me 3 minutes to finish off my presentation. If I may.
That's fine, Nompilo. Please go ahead.
Okay, great. Great, thank you very much. So I'm moving to the last aspect on lessons learned. And I think one of the key issues I'd want to encourage partners and CSOs that have joined this meeting is that there's a need to debunk the misconceptions. So the first misconception is that cybersecurity is only a national security issue. We are in the digital age, others call it the Icts revolution. And because of COVID-19, we have seen how the cyberspace has been useful, for online movements, for education, e-learning, for communication, but also even during elections, we have seen how several governments in Southern Africa are taking up social media in the cyberspace to raise awareness on their policies and their campaign strategies. So we need to demystify that misconception that cybersecurity is a national security issue or is only a national security issue, because everyone who uses electronic devices, everyone who has access to the internet can be a victim of a cyber threat, and therefore needs to be protected or needs to benefit from mechanisms that promote cybersecurity. And then also that cybersecurity laws are tools to punish social media abusers. Cybersecurity laws should be laws that ensure that that create safe spaces online, that ensure that people can safely communicate, can safely engage, can safely transact online, not a law to punish social media abusers. That approach is also very wrong and very misleading. And then also that the misconception that social media is a tool for promoting instability. I think I've already mentioned how social media has been useful, especially during COVID-19, even for access to information. So we need to also demystify the misconception that it's a tool for promoting instability. And then of course, as a result, we need a holistic approach to the importance of cybersecurity. So when we argue around a good cybersecurity law, I suggest that as CSOs, we should not only focus on the human rights components. I hope this is not controversial, but I want us to appreciate that there's need for a holistic approach to the importance of cybersecurity. Because when we're dealing with our policymakers and we just spearhead the human rights component only, they will just think, it's CSOs doing their work, it's CSOs promoting their own narrative. It's for instance, in Zimbabwe, you'd be accused of being enemies of the state because you are merely channeling the human rights component. So in order for us to achieve high results, it's important to also emphasize the importance of cybersecurity for investment, because usually external investors feel more comfortable investing in a country that has reliable ICT policies and ICT laws. We also need to make our politicians understand that cybersecurity is important even for their political aspects, for the social aspects, economic benefits, increased trade. So we need a holistic approach that looks at cybersecurity as important for all facets, so that when we then channel also the human rights component, it can then be viewed not as just a CSO advocacy strategy or lobbying strategy, but rather as a genuine concern for the need to develop good cybersecurity laws. And then, of course, I think in terms of aspects to note, what we have seen as a chapter is that most of the laws are being drafted with a mindset to curb social media abuse and to stifle free expression online. We've also seen that lawmaking is done on partisan lines, because when the parliamentarians argue in parliament or debate on the law, most of the time it's not really about what makes sense or the substantive provisions of the law, but rather just what my party is saying on this. If my party is saying, let's vote this cyber bill into law, then it's voted into law. So it's something that we need to note, that in the parliamentary processes, the arguments might not be as substantive as would wish, but rather just be done on partisan lines. And then, of course, that engagements with policymakers are not entirely in good faith. We have engaged with policymakers for a long time. You know, we agree on so many issues and we think we've settled on this aspect. And then when the law actually becomes law, you realize that some of the issues were not even included at all. So these conversations and these engagements are useful, but sometimes they might not be entirely in good faith. So it's always important to also have a backup strategy to continue spearheading the human rights agenda and the approach that you'll be proposing. And then in terms of key and impactful strategies, I would recommend capacity building of policymakers on ICT-related policies and laws. There's also need for a comparative approach. We have seen it work, making reference to other jurisdictions and international standards and best practices. It's very important. And then multi-stakeholder engagements as well. And generally just monitoring policy and legal developments. We have monitored this development since 2013, and that has helped to shape our approach, our position, and even our strategy when the law was eventually gazetted. So monitoring of policy and legal developments around ICTs is quite important, because you realize that at the end of the day, all of these developments will build up into developing one framework. So once we monitor them, we are able to also shape our advocacy strategies accordingly. Thank you, everyone, and my apologies for eating into the time.
Thank you, Nompilo. That was very instructive. I think we've sort of already identified that there are overlapping issues between what happened in Zimbabwe and what's busy happening in Namibia, and some of the issues that we have with our bill, you've already sort of encountered with the bill in your bill in Zimbabwe, and it's important that people hear these sorts of experiences and see what's happening in other parts of the continent, in other parts of the region, and close to us. So that's really good, and thanks for the presentation. So I would like to ask Thomas Zulu from MISA Zambia to please, what do you think? Should we do the break now and then do Zambia and Lesotho after the break, or should we just go ahead and do the program as is? What do you suggest? I'll go with what the audience suggests, what the participants suggest.